Swayam Prabha. Digital India. Educated India.
Greetings of the day, friends. I continue with the 10th lecture now. I was explaining what it means by the targeted dumping and how the comparison has to be drawn in case of this calculating the targeted dumping. Sometimes it can be a mistake where there can be allegations that the targeted dumping is being practiced. But as I said, it might be not an intentional practice. It can be for some unknown reasons, or it could be incidental that the price of the export of that product has lowered down. That can be certain instances. Like I said, if there is a increase in the production, or for some reasons there is a bumper harvest of the cotton, that can be one such reason. But to maintain the fairness while making the calculations, the provision has been included in this agreement, the agreement to check the practices of dumping, because the propounders or those who made this agreement or introduced this agreement, they were aware of the market complexities and the differences in the method of calculating the dumping practices or the dumping margin. So if there are doubts, or if there seems to be unfair method being adopted for calculating, or the allegations are merely for the sake of allegations, then it has to be checked through the legal parameters. So for this, they have introduced the provisions, and that it is stated like this: a fair comparison shall be made between export price and the normal value. The term used is the fair comparison. This comparison shall be made at the same level of trade, normally at the X factory level, and in respect of sales made at as nearly as possible the same time. X factory level, when the goods are ready after being manufactured and ready to be delivered outside the factory, that is the X factory level. And in respect of sales made at nearly as possible at the same time. So that means they are now ready to be sold, not that we start comparing it, what is the price of the goods that is available in the posh market, or in some local market, or in substandard market, but what is its factory price once the goods are now ready to be delivered in the market for its sold. So that gives the fair idea of the prices. But then sometime it is not only confined to the pricing at the factory level, but when the factors of production were utilized, what was the expenditure being made by that manufacturer to procure those different factors of production? That is now another very important issue. Why that has become an important issue? Because the manufacturing is no more confined to one country. It can be that the part of product that is manufactured in one country and the other part is manufactured in another country, or sometimes the entire manufacturing is done in one country but they are assembled in another country, or assembled in China. And how then we can calculate what should be the fair price? So the technicalities with regard to quoting the exact price has become a bit difficult nowadays. Let us be very clear. But for that reason, they have stated a fair comparison has to be drawn, that if we want, or if someone has a doubt what should be the actual price of this product, then that can be further asked by the person who has imported, or any country that has imported the product, to the manufacturer of that good. Due allowance shall be made in each case on its merits for differences which affect price comparability, including differences in conditions and terms of sale, taxation, levels of trade, quantities, physical characteristics, and any other differences which are also demonstrated to affect price comparability. So that has been very clarified in this very provision. I repeat this, this is 2.4 of the agreement of this agreement to regulate the dumping practices, or agreement that checks the dumping practices. So it clarifies this, how the fair comparison can be made. Then it also states due allowances shall be made in the same provision. It is added on its merits. That means realizing the merit of the situation or merit of the reason, we can take certain exemptions for differences which affect price comparability. That can be the reasons of the price differences. Now, one such can be like when the goods are made ready for export. Maybe they are made ready for export in advance and they are stored in the warehouse. Like I have stated, the goods are supposed to be delivered in 4 different quarters. But let's say the manufacturer has manufactured all the goods in the first quarter itself, and gradually it will export in different quarters. But the cost that it has to bear has already been now done with, and there is no further cost that the manufacturer has to bear. So far as the domestic production is concerned, that still is continuing. And let's say there is a hike in fuel prices. There is a, because of, let's say, some crisis in the Middle East, there is a hike in the fuel prices, and that has led to increase in the manufacture of the goods that now are supposed to be sold in the domestic market. So in that case, we cannot say the cost of the like domestic product is higher in comparison to the goods that now are supposed to be exported to the country concerned, and there is a dumping being practiced. So all that merits and all these situations and circumstances has to be taken into consideration, which affect price comparability, including differences in conditions, terms of sale. Sometimes the tax are raised for one reason or the other by the government of the countries. Levels of trade, quantities, physical characteristics, and any other differences which are also demonstrated to affect price comparability. It is understood that some of the above factors may overlap, and authorities shall ensure that they do not duplicate adjustments that have already been made under this provision. So they are strictly supposed to work under the guidance of these provisions. Then comes the third type of dumping, that is predatory dumping, or it is also considered as strategic dumping. Guidance of these provisions. This is the most crucial thing. Now, what is predatory dumping? Where the person, or mainly the manufacturer who dumps the product, is considered as a predator. Now, why it is considered as a predator? Because his target is, it is not like a sporadic dumping that once a while it gets the goods overproduced and now it has to get rid of those goods, and for that reason it is exporting it to a foreign market at a lesser price. That is not the case, like we have discussed that in sporadic dumping. Or neither is the case that most of the goods it is exporting in a foreign market, in the said foreign market, at a genuine price, or whatever the export price should be, at that very price. But maybe one or two of those quality of the products that are included, that are part of the large bulk of those quantities, or that are part of the main goods, they are the price of those goods are artificially lowered so as to target the consumers, or so as to target a similar variety of the product that is being produced by the country which is importing that goods. But here the aims are big. They have to create a long term effect. That is like a predator to eat up or to totally take away the foreign producers, or whoever are working in whoever are manufacturing the like products in the foreign market, or in the market where the goods are exported. So how it does? Predatory dumping is a strategic form of trading practice. The dumping practices termed as predatory dumping aims to drive foreign competitors or other form of competitors from the importing country out of the country, though it is like totally annihilation of that competitor. That means I cannot bear the foreign competitor. Now, how it is done? Let's say country A and this is country Z. All right. Now, country A, they have several multinational companies. Basically, these games are played by the multinational companies. Now, there is a multinational. They can sell the product or they can export the product to country Z. All right. They will follow the practice of dumping. Let's assume so. That is lesser the price, lesser the export price. Now, this lesser the export price is in comparison to the domestic price of the same good. Okay. So, the same good, if it is sold in the domestic market, that is the place where it is actually registered, this multinational firm is actually registered, the price of the same good is higher. All right, in comparison to export price. Now, they will continue to export it at a lesser price. Why they will continue? That whatever competitors are in country Z, they finally gets defeated, or let's say they finally surrender before this multinational company, and multinational company take these, or it follows the route of the takeover and assimilate all these competitors in its own. How it has done it? Firstly, it has lowered the price. Okay, it has lowered the price of the product, it is of the goods that is being sold in country Z. After lowering the price, what will be the consequence? All the competitors that are here in this country, although they are the domestic producers, they will either merge with this company or they will stop. Okay. After this, what will be the second step? It will, of course, it has suffered certain losses for certain period of time, and either these losses are compensated by the subsidies given by the government in country A, or by charging higher price from the consumers of this country A. Okay, that is how it compensates it, the losses it is suffering. Now, after it has captured the market of country Z, it can dictate its own price. This is how a predator works. So, finally, it will establish its monopoly in the foreign country. Now, prior to that, what is its situation in country A and how it has been able to play this trick? It has been able to play this trick here because it was not facing any competitor in country A, so it was having monopoly like situation. Okay, monopoly like situation in country A, or if not monopoly like situation, it was a dominant player in the market of country, and therefore it was influencing the price. So, whatever profit it earned from here, it was trying to compensate it with the losses it was bearing here in country Z, and finally it has captured the entire market of country Z. So, this is how the predator works. Not only capture the market, but all the rival firms, they have now merged with this company or this multinational company. So, predatory dumping is a strategic form of trading practices. The dumping practices termed as predatory dumping aims to drive the foreign competitors or other form of competitors from the importing country out of the competition. That is like the strategy behind it. From the WTO perspective, it can be said that practice of predatory pricing mainly covers reduction of price of product for short interval. That is like strategy to reduce the price and then to capture the market, so as to derive away the competing firms out of the market. Now, there was one such thing that has, with regard to the predatory pricing, there was a famous case in India. Now, where of course it has not gone far beyond that, it has not entered into a foreign market, but the target was to capture all the Indian competitors, and it was done by the Indian company itself. So, the Reliance company, when it started distributing the Geo SIM for free. All right. Now, can you imagine if we go by the fair trade principle, how can someone get things for free? Who is going to bear the burden? And that was kind of a predatory pricing being practiced by the Reliance company, distributing the Geo SIMs for free to annihilate those the rivals like Vodafone, Airtel, or make them to bear the losses so that they finally surrender before the Reliance company. And that was challenged as a predatory pricing practice. But predatory pricing is also connected with the anti-competition policy, that it was not a fair play with regard to the competition policy, because that was misleading the consumers and in a way trying to create an unfair market system in the country. And basically the idea was to create a monopoly like strategy. So predatory dumping succeeds if there is a predatory pricing, and predatory pricing has two effects: it can lead to predatory dumping, or it can violate the competition policy norms. The what I have stated is predatory pricing went to the direction of, in Reliance case, the predatory pricing was in the direction of violating the competition policy norms. Whereas when we see this, the predatory pricing from the dumping practices, then it was mainly the violation of anti-dumping regulation, that in any company or any nation allows its company to practice the predatory pricing to strategically capture the market of a foreign country, or strategically take over the companies from the foreign country. In the later stages, this also introduces opportunity to form monopoly or monopoly like situation for firms following the predatory prices and gaining higher profits as there are less risk factors left. So when it has attained the monopoly like situation, then definitely there are no competitors, no rivals. They can dictate their own pricing, they can code their own pricing, they can formulate their own marketing strategy. So that is like the risk factors that are always almost over. We cannot say that there are no risk factors left, but the risk factors are almost over. But that should not be sensed as a risk factor, but we can say the competitors, those who existed in the market, they are no more. What usually happens is that to attain monopoly situation, the firm or industry seeks support from the government, either in the form of direct subsidies or financial support through policy measure. Now there is something hidden. Mainly we cannot expect a company to bear such a long-term losses without seeking a financial support from the government or from any state funding agency. So there are chances that the such like practices do happen because of the state support being provided. Now that can be either in the form of direct subsidies. Direct subsidies are either in the form of financial gains or the financial support being provided, or indirect support through policy measure can be like tax exemption, reduction in interest rate, giving free electricity. All these are kind of the financial support indirectly being provided through the policy measure. This creates favorable business opportunities for such firms or industries, and they can continue with exports at lower price. It can be noticed that the use of subsidies, if unregulated, also creates threat of predatory pricing by foreign competitors to any importing country. Now that's very clear that behind this, sometimes the subsidy plays a great role when we question how the predatory pricing is being practiced. Now there are cases. One of such cases is China countervailing and anti-dumping duties on grain-oriented flat-rolled electrical steel from the United States. In this case, sometimes this dumping is such a issue that many a times countries or the companies, they are blaming the companies or the national practices only to gain something out of that challenges, or only to allow them to enter their market or to dictate their terms or to settle the business according to their own terms by putting the allegations that the goods that are being exported or the goods that they are sending to our country, they are being dumped. So sometimes that is not really proven, or there are lesser evidences, but partly there could be certain evidences, and mainly there are presumptions. So that is the situation many a times. Now when we talk about the China and United States, they have many a times made counterclaims. Okay, once China has put an allegation against the United States, and likewise United States also alleges against the Chinese exports to the United States. So that is like tit for tat in order to bargain or to settle the scores between the two countries. So here is one such case: China countervailing and anti-dumping duties on grain-oriented flat-rolled electrical steel from United States. However, this matter was not accepted, and appellate body discarded the claims made by China, stated as its reasons that Article 3.2 and 15.2 require the investigating authorities to understand whether the imports are the cause of significant price suppression and depression in the domestic price. Now, simply by alleging that there is a dumping being practiced, that is, the selling of goods at a price lower than the domestic market price, is not sufficient. There has to be something has to be present, that there has happened some kind of injury to the like domestic products. All right, the injury here means the economic loss has been suffered, and that economic loss is in the sense of price suppression and depression. Now, what is price suppression here and depression? Now, take the example here they have quoted of grain oriented flat rolled electrical steel that are being imported by China from the United States. China countervailing and anti-dumping duties on grain-oriented flat-rolled electrical steel from United States. So China is importing this from the United States, and what is the next step? That China started putting the anti-dumping duty. So what basically this act enables a member state to do, that they can start, once they have stated that the anti-dumping practice is being done, they will start with the negotiation, and if the negotiation fails, they will allow the goods to come. So they may not stop the goods to enter in their market, but they will start putting extra duties on it. And when the extra duties are imposed, they will claim that it is because your goods are being dumped in our country, so we will add extra tariff. Now then, sometime that matter is resolved through negotiations, and if that is not resolved through negotiations, then the matter is referred to the dispute settlement body, and then it is for the dispute settlement body to decide whether in true sense the countervailing duties that are being imposed against those dumping practices are fair enough. The two things that has to be decided: whether the countervailing duties being imposed by the country who alleges that dumping is being practiced, they are fair or not, and secondly, whether the dumping in true sense was practiced or not. So these are the two things. Similar such thing happened in this case also. Now, for this, the key that was suggested by the appellate body is the body after panel body. So if there is a dispute in the WTO system, firstly it starts with the consultation stage, where the parties, they try to resolve the matter by consultation that is done through diplomatic channels. If the parties fail to resolve the dispute by means of consultation, then there is a panel body, that is the first stage, and the matter is decided by the panel body. So if the decision is given, it can be that both the parties accept the decision given by the panel body, or it could be one of the parties is not ready to accept it, or it can be that they are not clear with the law, so they want this to be appealed. So the appellate body basically is the body after, or can be quoted as the final body to resolve the dispute. So here the matter finally was taken before the appellate body, which discarded the claims made by China, stated as its reason that Article 3.2 and 15.2 require the investigating authorities to understand whether imports are caused of significant price suppression and depression in domestic price. Now here, when the flat rolled electric steel was imported to China, whether that has led to the decrease in price, that is depression, is when there is a decrease in price. How the price will decrease? Because the product will face a direct competition with this US, the Chinese product will face the direct competition with the flat rolled electric steel from United States. So in order to sustain in the market, it has to reduce its price. Otherwise, the US product will take over the entire market. That is one thing. The next is there can be a price suppression. The price suppression is that, referring here the expected cost that are supposed to get higher in terms of the time period. So whatever was the factor cost today, those may, it's very likely that they will become higher after 5 years or after 2 years or 3 years. So in that sense, it would be fair enough to say the price of any product that we quote here today will be higher in that sense, not because of the profit margin has to be increased or the company expects higher profit, but another very fundamental reason is because the factors cost of production or all the factors, their price has increased. But if the company does not increases or enhances that price, which in due course should have increased, then we say that there is a artificial price suppression, or there is a price suppression because of some pressure being created. So that is where we consider that also as a kind of material injury when we try to calculate the dumping margin, that for due to the dumped products, that like injury has been created, that there is a suppression of the price in the market of the like product. Significant price suppression and depression in the domestic price. The appellate body, by applying the market rationality, affirmed the decision given by the panel. It emphasized that Article 3.2 and 15.2 of the Subsidies and Countervailing Measure Agreement expressly postulated an inquiry into relationship between subjects' imports and domestic prices of the product. Now, there are two things here they are trying to connect. As per the allegation that subsidies are being given by the various provinces of the US in order to increase the export of this flat rolled electrical steel. So in order to draw the connection, the first thing was whether there is a price suppression or depression, and then what it is meant under Article 3.2 and 15.2 of the Subsidies Agreement, which expressly postulated an inquiry into the relationship between subjects' import and domestic price of the product. That means Article 3.2 here deals with the subsidies being given for the export. If you recall, that covers the prohibited subsidies. Now, whether there is a direct relationship between the imported goods and the subsidy being provided or not. Consideration was taken of whether the effect of the items imported was to depress or suppress the domestic price of the like product in the market of the importing country. So mainly the focus area was whether, as a consequence of these products being imported, it has created price suppression or depression or not. And if they have not done so, then we cannot say the same has created any kind of market injury, or there is a doubtful case whether in true sense there is a the practice of dumping being done here. Appellate body in this case gave the decision keeping in mind the central aspect of free trade and the extent of the scope of protection justified in the case of subsidies and dumping being practiced. So they made it very clear that on what basis we can consider that the dumping has been practiced, not for the purpose of alleging the dumping, but when we are imposing countervailing duties. That was the reason. So here the countervailing duties, they are imposed by China arbitrarily without trying to find out whether there in true sense the dumping has been practiced or not by the United States. Subsidies for the promotion of export by the developing countries, does this constitute dumping? Now, there is a very crucial thing, that when we have discussed the agreement on subsidies and countervailing measure agreement, under Article 27 of that agreement, which talks about special and differential treatment, also there is a generalized system of preferences that exist in the WTO system. In all these categories, the developing countries and mainly the less developed countries, they are given exemption. When we talk in relation to the objectives that are set by the WTO preamble, which says the equal opportunity or an opportunity has to be created. Opportunity here means opportunity to export the goods have to be created for the developing countries and the less developed countries. So how can we expect those opportunities until unless there is a state level support or the state support for those exported or exporting products? And sometimes that could be the price of the export product can be lowered in order to establish some some, let's say, percentage of share in the foreign market. Whether that should also be considered as dumping of those products, that remains question. So if any product that is being introduced in a foreign market by a developing country, where the price of that product that is being introduced in the foreign market is lower than its domestic market, whether outrightly should be rejected as a dumped product, or we should consider that some flexibility has to be given, or some scope for the developing nation product has to be given. So that is well answered in Article 15 of the Anti-Dumping Agreement, where it says that developing countries expect special considerations from the developed countries, and it has allowed, but with what reasoning? It is worth referring here that such consideration for allowing special concessions are rather a matter of fact finding and should be substantiated with facts. After analyzing the facts, interpretation can be applied as to how far such consideration can be availed. This matter of interpretation to determine the scope of Article 15 arose in the case of United States anti-dumping and countervailing measures on steel plate from India. Now, this is a case where India is exporting steel plates to United States, and then the US has claimed that the dumping is being practiced by India. Now here you see that Article 15 creates exemption, but that was interpreted in a different manner in this case, stating that of course Article 15 creates exemption for the developing countries when dumping duties are supposed to be imposed, or when we try to find out whether dumping in true sense is practiced to create injury to the foreign market or not. But that is not a matter of right for the developing countries and the less developed countries. It is a mere a chance, or also that it is mere a kind of an exceptions being created. So exception cannot be a matter of generality, or it cannot be compared with a general principle of law where there exists a uniformity in the most of the instances. When we talk about the general application of a general principle of law, that means we believe that there is a uniform application of the law for most of the cases, for most of the countries. When we talk about the exceptions to the general principle of law, that means there is a minor deviation from what we consider as the general principle, and that is allowed depending on certain circumstances or depending upon certain objective criteria. So what is basically an exception created under Article 15 is simply a kind of an exemption, a deviation from the general principle, but not a main principle in itself. So since it is not a main principle in itself, it cannot be claimed as a matter of right. This was what the appellate body has stated here. It is worth referring here that such considerations for allowing special concessions are rather a matter of fact finding. Firstly, it has to be known whether it is the such like exemptions are required in particular case or in particular deal between a developed country or the developing country, and should be substantiated with the facts. After analyzing the facts, interpretation can be applied as to how far such consideration can be availed. So even these exemptions are there, but they cannot be applied for perpetuity or for very longer period of time. It has to be like this consideration has to be time bound. This matter of interpretation to determine the scope of Article 15 arose in the case of United States anti-dumping and countervailing measures on steel plate from India. It would be fair to say that based on the WTO objectives, Article 15 of the Anti-Dumping Act creates the scope of concession for developing and less developed countries and is not a matter of statutory basis, but rather an opportunity for development. Now, this exemption was introduced knowing the fact that developing countries and less developed countries, they must also get the chance for development, and therefore that at the initial stages they may wish to have the export price lesser than the domestic price of the same product. So in that regard, they have been given the opportunity for development. With the promotion of free trade among member states as a background objective, subsidies for welfare and development also require searching for the limits that need to be applied between development objectives and competing interests. So on the one side, there are development objectives of the developing and less developed countries, and on the other side, there are competing forces of the market. Now, when we talk about the competing forces of the market, then we have to be very fair that competing forces of the market can be from the side of the developed country, from the side of the other developing country. I mean here, like, there can be a situation if India or any particular developing country is exporting its good to, here we have taken the example of the developed country, it is exporting its goods. Now let's say one developing country is selling its product to another developing country at a lesser price, lesser than the domestic price of that product. Then what will be the allegation? So can the another developing country which is importing the product of that developing country allege that the dumping is being practiced, and whether the country A which is exporting the product can take the excuse under Article 15? So it has to be seen in that light also. So in that regard, we have to be very clear with the objective criteria while finding what are the effects of dumping, whether in true sense the injury is being created in the market of the developing country where the goods are being exported by one of the developing country, and if there is kind of an injury being sustained, that also for a certain period of time, then definitely we can say that the dumping is being practiced against the market of the another developing country. So that of course these things are technical, but then we have to be very objective here, and is not a matter of statutory basis but rather an opportunity for development. With the promotion of free trade among the member states as a background objectives, subsidies for welfare and development also require searching for the limits that need to be applied between the development objectives and competing interests. So far as the case by case consideration is concerned, the panel body and the appellate body are guided by the WTO objectives and purposes, that is for creating fair opportunities to trade among the member states. So the WTO and panel body, they are not simply applying the law as it is laid down, but they also try to find out what is the objective criteria and for what purpose these kind of state support are being provided, whether in true sense they are provided for the practice of dumping or they are provided so as a kind of startup for the upcoming industries. Apart from such initiative taken by the WTO, it is proposed that nations while trading establish coordination among themselves as there exist differences at economic level of every nation, and such difference is one of the reason for trade practice of dumping. Now the trade practice of dumping is one of the key reason is that the economic situation of different countries differ. Free trade promotes market efficiency, which is a positive aspect in the market. However, in contrast, several multinational practices unethical market strategies such as predatory pricing in the present free trade market structure, that we have already discussed very broadly. The trade practice of dumping is currently practiced. It has significant anti-competitive effects that we cannot deny. The dumping mainly hits the features of market competition or the competitive features of the market. If anti-dumping competitive effects distorting the market efficiency. If anti-dumping policies are to guard against such effects, anti-dumping rules need to shift towards competition policy, criteria for promoting market efficiency and to attain the other WTO objectives. So one in any case cannot ignore that until unless we draw the norms of competition and include them, we draw the norms of competition at a global level, and if not all, but we include certain parameters of those norms just in order to make comparison that what will be the effect of dumping, what not only dumping but what will be the effect of subsidies being practiced for a longer period of time or given beyond certain extent to the fair competition or the fair features of the competition, then what should we do, or whether we should allow this giving subsidies to that extent, whether we should allow the dumping being practiced to that extent. So at least in order to test the limits, we must think of, or at least the WTO member states of the WTO and General Council and the Ministerial Conference, they must give a thought to it to include the features, at least some of the features of the competition policy, to set the norms for testing the anti-dumping measures and also measure to understand how far subsidies should be given. As a downside, anti-dumping measures are also prone to be used as an instrument of protectionism. Threat to impose such measures without determining the effects means substantial procedural cost and forcing small companies to compromise. Now, that is very rightly said. There is a negative aspect because the remedy to it is to impose countervailing duties. Like if country A states against country B that it is practicing dumping, so they can, of their own, unilaterally impose duties against the products from country B. But that, in a way, cannot be denied as a means of protectionism. This was debated during GATT time, while I was referring here about the Kennedy Code, and even prior to that, it was debated that if we allow countervailing measures, if we allow the extra tariffs to be imposed on the dumped products, that in a way can lead to market protectionism, and that market protectionism may not be for the genuine reasons, but for could be for the reasons to protect their own domestic industry. So that kind of thing have, or that kind of feature has shown its colors here. Threat to impose such measure without determining the facts means substantial procedural cost and forcing small companies to compromise. Now, what is the effect if someone is trying to disapprove the dumping being practiced? Like if there are allegations and now it has to disapprove that that is not the genuine allegation, then these things are very expensive, and not only expensive, it require quite much of the technical knowledge of the things, or they have to acquire the tech, or sometimes hire the technical skills or the skillful person. So that all is a both lengthy procedure and an expensive procedure to for disapproving something when there are allegations. So finally what happens, the upcoming companies or many of the companies from developing countries, they believe or they think of an alternative, that is to make compromises, that sometimes that instead of going for this lengthy procedure, they may accept the terms that are being dictated by the companies who are alleging the dumping practices, or the state which is alleging the dumping practices. So that thing has to be taken into consideration very seriously. Now take the example, so it is not only confined that dumping is being practiced and allegation, it could ruin the economy also. For example, like US is a big country with a very strong economy, and multinationals from the United States, they allege that some of the companies from Cuba, they are practicing dumping, or they are introducing the products in the United States following the dumping practices, and based on this they simply start imposing the countervailing duties. Now what will be the effect? I mean, just imagine, Cuba is a small country, their companies, they have limited companies, and they will suffer a severe loss, and they may not wait for a very longer period of time that what will be the judgment, whether the judgment given by the appellate body will be in their favor or not. So in such situation, they may prefer to go for compromises. So that is what here it means, that there are like downside also of these measures, and more clarity has to be brought in this agreement. While establishing link between dumping and subsidies, member states need to consider objectively when it comes to imposing anti-dumping duties. It should be clarified whether the use of subsidies is justifiable or not, or subsidies are used to attain the WTO objectives. Repeatedly, the term subsidies is also used because that becomes a supportive pillar for dumping being practiced. So here, if it is strictly checked that subsidy is not used for unjustifiable purposes, then definitely the practice of dumping will be reduced, because no firm will take the risk of selling a product in a foreign market at a lesser price for a very long period of time, until unless it is sponsored by the state in one form or the other. So that kind of thing is very relevant here to be discussed, and very relevant to be scrutinized whether the practice of subsidy is being checked thoroughly or not. Then is, before putting the allegations or before imposing the countervailing duties, it is very important to know whether there is a market injury or not, and that has to be determined. So, a determination of injury for the purposes of Article 6 of GATT 1994 shall be based on positive evidence. There has to be something positive in that respect, clearly signifying that the dumping has been practiced or the product has been dumped in their market, and involve an objective examination of both the volume of the dumped product, dumped imports, and the effect of the dumped imports on the prices in the domestic market for like products, the consequent impact of these imports on the domestic producers of such product. Now, how the dumping margin is determined, or let's say how the injury is determined. Firstly, it is like volume of the dumped imports. The first is like if the import or the goods that are coming from the foreign market, they are of very less quantity, although it could be the price is reduced, the price is artificially reduced, but whatever product is entering from foreign country in a particular market, that is of very less quantity, or what they say in WTO, de minimis level. That is the maximum level that can be ignored, or the level which cannot create any harm. So, if there is a very less volume, then we can ignore, there is no need, we cannot expect any such injury. Like if India is a big market with a very dense population, and if let's say something we get only in hundreds, okay, then that will not affect the Indian market. Second is volume of the dump imports, then is the effect of the dump imports on the prices of the domestic market for the like products. So, if the same product is being produced in that very country where they allege that the goods are being dumped, there is very less effect or no effect on the prices of like product. All right. Like India grows wheat, okay, and let's say India also starts importing wheat, and there is a very minor difference, maybe the difference of 25 paise or even difference of 1 rupee to 5 rupees. So, that will be not very effective in the Indian scenario, because here many of the people, they have different economic status, so that will not fluctuate the demand of the Indian wheat in that respect. And the foreign product, even if, or the foreign wheat, even if that enters into the Indian market at a minimal lower price than what it is sold in its domestic market, may be in little terms considered as the dumped product, but while calculating the injury or calculating what is its effect in the Indian market, that will be almost negligible. So, in such cases also, the WTO does not take into consideration if the effect is almost negligible. Almost negligible in the sense, firstly, volume is very less. Secondly, the price difference of the like product is very less, and there is almost negligible chance of creating any reduction in the demand of the like domestic product. Next is the consequent impact of these imports on the domestic producers of such product. Now, what is the effect on the producers who are producing the like product? That also has to be analyzed. If they do not find themselves to be at loss, then there is no need to claim that the dumping is being practiced and we need to impose countervailing duties. In that sense, what will be the criteria adopted by the appellate body, that whether we should promote the idea of free trade or not? Basically, one has to keep this in mind very clearly, that if appellate body finds the product is being dumped in a particular country and it allows the imposition of countervailing duties, then that means it is going in the direction of protectionism. So, the primary objective of the WTO was or is to promote free trade. That means liberalization of the trade, reducing any such regulatory measure that imposes restriction. So, if, and when we talk about the dumping as a practice does not creates hindrance for the free trade. Basically, it does not give the fair value of the product that is being exported. And then after realizing that even if the price of the export product is not very fair, but it is not creating any negative effect in the foreign market, so why should the appellate body, or why should any dispute settlement body of the WTO, any part of the dispute settlement body of the WTO, impose restriction? So if they simply start imposing restriction for the minor allegations, that means they are in a way moving in the direction of protectionism. So they, in that cases, they do not go in that direction. The consequent impact of these imports on domestic producers of such product. With regard to the volume of the dumped imports, the investigating authority shall consider whether there has been significant increase in dumped imports either in absolute terms or relative to production or consumption in the importing member. Now, when we talk about the volume of import, we also see whether the volume has gradually increased or not. And if it has gradually increased, what is the level of consumption by the consumers? Like, let's say initially something was imported into India for the quantity was 10 quintals, and there were some rumors that probably this product is dumped. In the next year, the same product, instead of being imported and the same quantity, that is the 10 quintals, it has increased to 15 quintals and then 20 quintals. But let's say if in the first year it was 10 quintals, then the next year it was 15, in the third year it has gone down to 7 quintals. So that is not the hike in volume. So if there is an ascent in the volume repeatedly or in frequent terms, then we can consider that probably there has been something like a strategic dumping, targeted dumping, like that. With regard to the volume of the dumped import, so that is basically the investigating agencies to find out or to figure out whether the product is being dumped or not, by finding out whether the volume has been increasing on an annual basis or a biannual basis or not. With regard to the volume of the dumped imports, the investigating authorities shall consider whether there has been a significant increase in the dumped imports either in absolute terms or relative to production or consumption in the importing member. So either this can be seen in the two terms: there is increase in the import of that product in the Indian market. Sometime whether it is the increase in import has remained constant, but the increase in its purchase by the consumer has increased. So the consumption has increased, but the quantity that is being imported remains the same. So that both the things has to be seen in a relative manner. With regard to the effect of the dumped imports on prices, the investigating authorities shall consider whether there has been a significant price undercutting by dumped imports as compared with the price of the like product of the importing member, or whether the effect of such import is otherwise to depress price to a significant degree to prevent price increase, which otherwise should have occurred to a significant degree. This we have explained in terms of price suppression and price depression. A determination of a threat of material injury shall be based on the facts and not merely on allegations, conjecture, or remote possibility. So when we say that there are chances of dumping being practiced or there is a threat, then it should not be simply based on presumptions that we are expecting it. Why we are expecting that dumping is being practiced? Because the consumers, its consumer has increased, or because the volume that is being imported into any particular country has increased. That is not the criteria. There has to be a proper evidences. But as I said, the countervailing duties can be imposed, but then there can be repercussions also. So what it says, that is why the concept of injury or the determination of injury in the context of dumping practice has been explained in detail in this very agreement, so that the member state should not go for tit for tat practice, or they should not in a way adopt a protectionist measure by applying the provisions of the dumping agreement or the agreement on anti-dumping practices. That is not what the framer of this agreement wanted. So that is why they have emphasized various criterias, various, let's say, standards that has to be proved prior to imposition of these the countervailing duties or prior to making the allegations. A determination of a threat of material injury shall be based on the facts and not merely on allegations, conjecture, or remote possibility. Now, what are these practical aspects that has to be seen? A significant rate of increase of dumped import into the domestic market. So, there has to be a significant increase in that quantity. Significant increase can be the graph has grown, is going up, like if we say this divide it in 5-year terms, or like per year, sorry, the first year, second year, third year, fourth year, and quantity 5 quintals, then this is 10 quintals, 15 quintals, 20 quintals, 25 quintals, and per year it is going hiking out, and it is there is no, in all these calculation and all these years, nowhere it has gone down, or we see that the growth in demand has gone down. So then there will be, if not we can say it with certainty, but there are chances that dumping is being practiced. So that is what the act says here. A significant rate of increase of the dump imports into the domestic market. Next is sufficient free disposable or imminent substantial increase in the capacity of the exporter, the manufacturer who is exporting. Suddenly it has started manufacturing in higher quantity, or we see that there is a jump in its production level, that can lead to some kind of presumption that it leads to material injury, or it can lead to material injury in the domestic market. Whether imports are entering at a price that will have a significant depression or suppression effect on the domestic price. As explained, that the prices that is being quoted here, whether that creates, or there are chances it will create depression or suppression effect on the domestic price of the country where these goods are imported. So that also has to be taken into consideration, or seriously into consideration. So out of all these factors, we see that price suppression and depression is very key, and then the increase in the volume, a rapid increase in the volume with its continuity, that leads to, or that can lead to a presumption that probably the dumping is being practiced. With this, we end the topic of dumping, and we will start another theme in next lecture series. Thank you very much.